So, hi everybody, welcome back to Law Hero. My name is Jen and I make videos about the law, and tonight we're doing FE1 Constitutional Law from November 2020. I actually never said in my last video it was November 2020, but you'll see from the thumbnail that it was. Okay, so we're just going to dive right into constitutional law, okay? So the first question was an essay question that asked, the Supreme Court's decision in Maughan v Ireland and PV judges of the Circuit Court provide important clarifications on the rule in relation to standing in Irish constitutional cases. In particular, the decisions highlight the ongoing significance of the jus tertii principle. So jus tertii means you take a case on behalf of somebody else. So basically in these two cases, and I've outlined it in my ebook about these two cases, in Maughan v Ireland, that was around the electoral acts and whether a candidate had to be a man or a woman, and whether the plaintiff here, who was a Fianna Fáil TD, whether he had standing. And he did. He was able to prove standing, whereas PV judges of the Circuit Court, that was obviously not to do with standing, because the case was about him, and not about an act like it was in the other one. But that discussed jus tertii because it was a retrospective illegality of, it was actually to do with Norris, David Norris's case around the Criminal Law Act 1935, which made homosexuality illegal. So basically this guy, P, wanted to take cases on behalf of other people, but the court held he couldn't do that because he didn't have jus tertii. And then basically both cases said that Cahill v Sutton is still the most relevant authority around locus standi. So I have all that in my ebook. Locus standi is like one of the basic things you need to take a constitutional case. So yeah. Okay, so the second question is around freedom of expression, and you know, kind of like the right to, in a democratic society, you have a right to information about what's going on, but at the same time you have cabinet sorry, not cabinet, confidentiality. If you have investigations going on, they need to be kept private. So yeah, I mean, this one's a little bit like, reminds me of the Mann Tribunal. The third question is an essay question which quotes Kearns v McGuinness and O'Brien v Clerk of Dáil Éireann. It's an encroachment by the courts on matters that are reserved by the Constitution to the Oireachtas. So this is separation of powers, and this is judicial deference to the legislator question. And yeah, that's a pretty handy question, I think. Question 4 was the case law question. Question 5 was one of those long title questions whereby there's an act brought in and there's a penal sanction, and the minister has the principles and policies to make such orders and all of that. Question 6 was an essay question around the right to earn a livelihood. Means that it has limited of any value as a separate constitutional entitlement, and would be more usefully regarded as a constitution's broad commitment to the protection of property rights. Do you agree? Question 7 was another act enacted, whereby this was an act to regulate efforts to influence public policy in order to ensure the public interest in democracy. Section 3 of the Act said that any person engaged in an act intended to influence an elected representative to form a particular view on a matter of public policy is required to enter their details on the register of policy influencers. And then the minister can make such regulations as appear appropriate, and again there's a fee. So there's a few things going on here. So you have right to privacy, as in this is basically any person. So if it was a natural person, for example, people would know your political moves, by the way, so your right to privacy would potentially be infringed. And then you're penalized with a fee, so that's another encroachment on your freedoms. And also it's really undemocratic and it's probably disproportionate. So the principles and policies will come in here as well because of the powers given to the minister. Okay, question 8 then is a problem question. So this is somebody who has a mild cognitive disability. He's hospitalized. It seems that the hospital is concerned about him and have made him a ward of court. The application is based solely on evidence from the hospital staff. So you would imagine here that there is, this is very subjective, and his constitutional rights. So when he fell off a bridge, so he's basically, you could argue he's being detained unlawfully by the hospital because the High Court has granted the application even though the evidence was very one-sided, and now he's in a secure unit and the hospital is told to make a fresh application to have him released when his condition has improved. His sister is concerned about the situation and seeks our advice on any grounds of constitutional law that have led to his detention. So what we would talk about there is personal liberty and fair procedure. So here you would have the rules of natural justice. You would have audi alterum partem because we've only heard the evidence of the nurses. The decision needs to be proportionate, like they've only heard him laugh. So this is pretty heavy-handed response. I think it was actually a fairly good paper, and yeah, I think it was very fair paper. I've put up some of the chapters. If you need any more help, just go to lawhero.eu, constitutional law, and I will see all of you guys in the next one. We 4 down, 4 to go. Thanks very much for watching. I'll see you in the next one.